Hey, here we are for Torts in Chapter 4. This could be a very long and dry chapter, so I've broken it into two. We're going to do intentional torts, and then we'll do unintentional torts. So the questions we're going to answer are, what is the purpose of a tort law? The types of damages that are available in tort lawsuits. Two basic categories of torts. What's deformation? Deformation, and two types of deformation. We're going to identify the four elements of negligence, which falls under unintentional torts, and then we're going to look at what strict liability is, and then in what circumstances strict liability is applied. Those are the items we need to be concentrating on as we go through this chapter. So let's get started. So, what's the basis of the tort law? Right here, why do we have tort law, and why do I care? Tort law is a civil action on the other side of the criminal action, and one of the basis is it allows one person to bring a suit against another person of a personal nature. That other person could be a business. So it's not just one person to one person. It could be one person to a corporation, meaning that there may not be criminal action there, but there has been a wrong committed. The function of it is to provide an injured party with a remedy for this injury of sorts. So without tort law, there would be no system to address the wrongs committed by one person against another if it fell outside of the criminal jurisdiction of criminal law. Tort law has caused some controversy, as we'll see as we go down through here. There are two types of damages that are available or come out of the tort actions. One is compensatory damages, and that's just for the damage or the injury incurred. And then there are punitive damages, which goes beyond the damages or injury incurred. And usually punitive damages are something that is very extreme. They use punitive damages to really punish the defendant, so that it never happens again. There is tort reform in our country, and it's because there's been many lawsuits that some people have considered frivolous, with excessive damages, and it's been costly. And that means physicians, when they have to have such high liability insurance, they also will order a lot of unnecessary tests just to cover the possibility of not being sued for negligence. There's been some class action movement where there's been a Fairness Act that says cases involving large numbers of plaintiffs and large amounts of potential awards in the federal courts, they've kind of moved that up to the federal courts so they can have more control over that. There's also at the state level, they've been limiting the damages that can be assigned or awarded, and they've banned some punitive damages because things did get out of hand, medical malpractice, several areas. There's further limits on some of the damages. There's limits on attorney fees, and there's the losing party pays both parties' expenses. So what that has done is caused people to step back and say, no, if I lose this, if this is frivolous, I'm going to have to pay dearly for it. So there is some tort reform going on. I think a lot of this, if you look at the tort reform, depends on which side of the table you're on. If a lot of tort reform has come out of businesses saying that the awards have been extreme, you have to kind of sit back and wonder or think, depending on where you sit in the disagreement or the dispute, is it frivolous or not? So there are classifications of torts, and I've got 3 of them here. There's some special classifications we'll look at later on. The first one is intentional. Then there's unintentional, which is actually negligence. And then we'll look at cyber torts, which is a relatively new field, still developing, a little bit harder to handle than the intentional or the unintentional. But for overall, you really need to remember what the purpose of the tort law is, why we have it, very much so, and what is it, what is tort? A tort is civil action rather than criminal action. A tort action is brought on by an individual, not by the state or by a federal agency. So here's a question for you, true or false? A tort is a civil action brought on by one person against another. True or false? We're going to look at intentional torts against persons first off, and we have a whole slew of those. So let's start by the obvious ones. There's assault and battery. And so assault is the threat of harm or offensive contact. Just the threat of it. It has to be very radical and horrifying in some ways. And that could be somebody pointing a gun at you and threatening to kill you. So it has to be something that gets immediate harm. Is immediately harmful and very offensive. The other side of assault is the battery, and that's if the act is actually completed. The threat is followed through. So you can also have damages awarded for emotional harm, or loss of reputation, or physical harm. One of the defenses would have to be self-defense or the defense of others as you're going through this. But you have assault and battery, you hear that a lot. Just remember that assault is just the threat of it, and battery is the carrying through of that threat. And here's a question for you, and I have questions, but we'll say question. Select all that apply. Which of the following are categories of torts? So you can take your selection there. The next intentional tort is false imprisonment, and that's an interesting tort. False imprisonment is the intentional confinement or restraint of another person without justification. Now, interestingly enough, businessmen have some gray areas that they have to be careful of. You have to be fairly justified that somebody has shoplifted to confine them long enough for the police to come. That's a very gray area. In fact, I was at Walmart the other day, and somebody came out through the arms or the devices that go off when you walk out of the store without paying for something. And the guy just turned around and smiled at the person standing there and walked off. And I looked at her, and she says, "There's nothing I can do. I didn't see him steal anything." So evidently they have in some way been warned about not confining somebody without good just cause. So that's something interesting to be aware of. Here's a situation, though, where it is the county that is actually being sued for false imprisonment. There was a gentleman that was arrested, and he was scheduled to be released, but somehow somebody from the county put papers for somebody else in his stack that said he must be held. And he was held for an extra, I think, 16 days. And nobody would listen to him, and nobody would check into what he was saying, that he was not that person. He ended up getting damages of $22,700, and also had non-economical damages of $180,000. They appealed it, and they lost because it was very obvious that he was not that person, and they falsely imprisoned him. So that was a tort that actually was against a county. There are, the other one is intentional infliction of emotional distress, and that would cause, because by outrageous conduct, and again, here's another interesting thing. You can cause emotional distress if it's limited by freedom of speech, and it's the First Amendment, and if it's about a public figure, which is very interesting as you look at this, because a public figure puts themselves out in the public and should expect some type of response, or I guess you're supposed to get a thick skin with it. But here is an example, and this is an interesting one. Dave gives Beth a swimming suit that will dissolve in the water, and she goes swimming in it, and the swimming suit obviously dissolves, and she suffers extreme embarrassment. And it asks, is he liable, is Dave liable for this? And under the circumstances he is, and he can be sued for damages for that. There's defamation, and I think we've all heard of that. For defamation to happen, okay, you can do it orally, and that's called slander. You can do it in writing, and that is called libel. Now, for either one of those to be applicable, it has to be a statement of fact. You can't say, well, in my opinion, but you have to state a fact that is defamatory, and it has to be said to another person, not to the person that you are defaming. And because libel is written and can be circulated, it's fairly obvious, okay? So your general damages are presumed, and showing an actual injury is not required because it's in writing and it is available. The evidence is concrete. Whereas for slander, this is temporary in quality. It has to have proof, such as proof of injury. What was the actual economic loss? And the exceptions to all of this, for this proof of injury, there are 4 things that are an exception to that. One is to say somebody has a loathsome disease, such as a sexually transmitted disease or mental illness. The other would be talking about, let's say, a lawyer, and as a matter of fact, stating that they are corrupt, and when in fact that it's not true. So you can't threaten somebody's livelihood with falsehoods. You also can't say that somebody's been imprisoned for a serious crime. And the final one is to make a statement about an unmarried woman and say that she's unchaste or has engaged in serious sexual misconduct. None of these, okay, these 4 right here, require proof of injury, even though they are said rather than written, because those are very serious and are looked at upon the law as being things that threaten somebody's livelihood or seriously threaten their reputation. Another question here. True or false? Libel is spoken defamation, and slander is written defamation. And remember which of the two requires the most, shall we say, proof of injury? Which one requires the proof of injury, and why? Invasion of the right to privacy and appropriation. Invasion of privacy. We all have our boundaries for our privacy. And if you remember, privacy is not written into the Constitution. It's sort of an implied thing, or an implied act. So there are 4 different acts that qualify as invasion of privacy. One is to intrude on an individual's affairs or their seclusion, such as going into their home without being invited, or looking into their bank account, or eavesdropping by wire, or listening in on a conversation, and then that's an invasion of privacy. Publishing information about somebody in a false light. Public disclosure of private facts that typically people wouldn't have privy to. And then you could appropriation of identity, and that's using somebody's name or picture or other likeness for commercial purposes. And that necessarily doesn't have to be a living person. Let's say you wanted to take advantage of Elvis Presley's silhouette and use it in an advertisement. Elvis Presley's estate would come and throw a fit and probably take you into court over that. So that's an invasion of privacy tort. And states have different rulings on to the degree of the likeness, needed to impose a liability. You have fraudulent misrepresentation, and that is misrepresentation of facts or conditions with the knowledge that they're false. So making a false statement with disregard for the truth, or the intent to induce another to rely on a misrepresentation. Leading somebody into fraud is what they're looking at here. There have to be damages, and there has to be a connection between the fraud and the damages for that to be valid. So it says, to constitute fraudulent representation, a statement of fact must be involved. So what we're saying is you have to be making a statement of fact that is false, and you have to be presenting that statement of fact as truth, when in reality it isn't true. And you're doing it on, and it can't be in a general sort, such as saying, this is a best product other. You have to be giving them specific reasons why, and those reasons have to be fraudulent. And then you have 2 here that are very interesting. Wrongful interference, because this kind of goes counter to some of the business things that business relationships that we have. The first one is wrongful interference in a contractual relationship, and that's where somebody would interfere with a contract and cause a breach in it. The other one is wrongful interference with a business relationship, which this is the one that you would kind of go, and know when to draw the line on that one. Because everybody is always wanting to get customers. I guess the best explanation of this would be if you had 2 dealerships sitting next to each other, and obviously they both want to, get the most customers, so they both have the best deals out there. But a wrongful interference would be if somebody were on one car lot and one of your salesmen from the other car lot actually walked over and persuaded them when they're in the middle of a deal to come to their car lot because they could give them a better deal. That would be a wrongful interference in a business relationship. There are certain lines that you can't cross. As it says here, we depend on whether a business is attempting to attract customers in general or to solicit only customers who have already shown an interest in the product or service of the competitor. You have to be very careful. So, wrongful interference of a business relationship. It would have to be blatant. And walking into their showroom and pulling a customer out would probably be blatant. Then we have intentional torts against property, and that goes down to trespassing on land when you're not invited, and trespassing on personal property, and that would be somebody coming in and using your personal property, damaging it, and then leaving. Somebody coming into your house, number one, that's trespassing. But sitting down and then using your television and damaging it and then walking out. Okay, that's trespassing on personal property. And the final one we've got here is that falls under the intentional torts against property is conversion, which is the criminal version of theft. If somebody were to use some of your personal belongings, damage it, and then return it to you, or let's say you lent something to let's say you lent a computer to a friend and you stopped by to pick it up and they said, oh, I gave that to my girlfriend's little boy to play with and I told him he could have it. That type of thing is conversion. Or if you unlawfully take personal property and then sell it to somebody else, or you buy stolen goods, is a good example of it. And then you have disparagement of property, which is another interesting tort. And that's when you slander a business or you slander somebody's property. Publication of false information about another's product or another's business could be slander. And slander of title is when a publication denies or casts doubt on another's legal ownership of property. It kind of brings things into question. So that's called disparagement of property, and that's a tort. A question here: appropriation is considered an invasion of privacy tort. Is that true or false? And that is all of the intentional torts. The main thing you want to remember is the way or the number and what they are. Because if you start at the top, you have, if I can get to the top, you have assault and battery that we looked at. You have false imprisonment. You have infliction of emotional distress. Under this, I imagine you would also put stalking. You have defamation. I'm bound determined to call that defamation. And there are all kinds of little elements that must be supported. You have invasion to privacy and appropriation. You have fraudulent representation, abusive or frivolous law litigation. I think I skipped that one. And that's where if you bring a lawsuit against somebody and it is frivolous, you can actually have recourse with that. There's wrongful interference. So you have to be careful about what you do within your business and how you acquire customers. There's intentional tort against property, again, trespassing on land, trespassing on personal property, conversion, then there's disparagement of property, and again, that goes to you're really looking at a product or a title to something. So those are your intentional torts. Now, for it to be an intentional tort, again, I need to get to the top. For it to be an intentional tort, you have the defendant has to have intent, and intent means that they intended the consequences of his or her act and knew with substantial certainty that certain consequences would result from that act. So they intentionally know that there may be harm that comes from their actions, and that's why they're called intentional torts. Okay, on to unintentional torts. Thank you.